So, David, let me start with you. You two met arguing Bush v. Gore.
Right.
Now, all these years later, is there anything you would have done differently when you approached that case? And for both of you, a second question, having thought about it, is there anything the court might have done differently to try to avoid some of the problems that came from that decision?
Well, I can't think of anything that I would have done differently, given what some of the justices have said after the fact in terms of why the decision was made. I can think of a lot of things that the court could have done differently, like change the result. But I think that each of the justices on the court had a pretty strong view, and you see that both in the various dissents and in the majority opinion as to how they thought things ought to come out.
One of the dissents said that what was really lost in this case is the credibility of the court, its role as a neutral arbiter, or words to that effect. Do you worry about that?
I think the Supreme Court has had a series of decisions over the years that I would disagree with. Plessy against Ferguson, Dred Scott decision, the Japanese internment decision. And whether or not you put Bush v. Gore into that category, I think depends on your perspective. But my point is not whether Bush v. Gore was right or wrong, but that the court, I think, can survive, and its credibility can survive, decisions that in retrospect people look back on and say were wrong.
Anything to add to that, Ted? Or
Well,
I know it came out well from your perspective.
I think it's important to emphasize that we were operating on an extraordinarily tight schedule. There were two arguments in the Supreme Court. The first argument in the Supreme Court came 14 days after a Florida Supreme Court decision. So we had very little time compared to what usually goes on in the Supreme Court to prepare briefs and to get ready and to do an argument. And then the decision came down just a few days after that. And then in the second case, which is the one that's called Bush versus Gore, the decision from the Florida court came down in the evening or in late afternoon on a Friday, and we were filing papers on Friday night. We had to file briefs on Sunday, and the argument was on Monday. So we were, I think it was maybe a good thing that we were moving so fast. You asked whether we could have thought of things later that we could have done differently. I don't feel much about that, that we should have done or could have done things differently. I'm actually pretty proud of both the work that David's team did and our team did, and the Chief Justice commented on this at the argument that the lawyers did a really pretty darn good job given the time constraints. As far as the credibility of the court is concerned, I believed, of course, that the court should have done something about what was happening down in Florida. David disagrees, but the point of the thing is that we put courts in difficult situations all of the time. It's not easy to decide these cases, and there are no perfect answers that everyone would think was just the right outcome. Yesterday, the court heard argument in the case involving the Affordable Care Act. Congress drafted a very difficult statute that is incomprehensible in many ways, and the court probably will come out with a decision that a lot of people will say, well, how could you do that? Well, Congress created a mess. And in a sense, in Bush versus Gore, there was a scramble down there. There was an election that was really too close to call, within the margin of error. It could have come out either way, really. And there were things that were going on that both sides, I think, were critical of. But at the end of the day, the American people still respect the Supreme Court more than any other political institution in America, more than the president, more than Congress particularly.
Yes.
So the Supreme Court's done pretty well.
Oh,
I think Ted also makes a point that's worth emphasizing, which is that courts have to make decisions all the time that are unpopular. And one of the issues that we have, if we believe in the rule of law, is that we have to accept those decisions. And you can't pick and choose and say, well, I'm going to take this decision on Gideon against Wainwright, but I'm not going to take this decision on Bush v. Gore. So I think you have to, if you believe in the rule of law and you believe in the role that the courts play in our society, is that once you've had your argument, you have to accept, and I think one of the things that Vice President Gore did in a very statesmanlike way in his concession speech is to recognize that however much he might disagree with that decision, it was one that under our system of government, which is a good one, has to be accepted.
You called it a heavy-hearted but kind of noble decision in your comment in your book from Gore. I've read your book, which is really just marvelously written. David, you won't like this, but I was telling Ted, it reminded me a little bit of Reagan's autobiographies, which are my favorite of the presidential. It's just clear and smooth. And you spent a lot of time talking how you came to take this case. Could you summarize? 1 minute, you're opposing each other in one of the great cases, and the next time anybody looks, there you are on the same side.
After Bush versus Gore, David and his wife Mary and my wife Lady and I we all four of us became very good friends. We did some traveling together, riding bicycles in Europe and having dinners and drinking.
I've read wine came into it.
The red wine keeps coming into it, but that does help.
Fortunately.
That does help relationships. But we had grown in our relationship, and when I was first brought into this case, or given the opportunity to do this case, because of my reputation being a lawyer that had often represented conservative causes, all of us felt that it was very, very important to send a signal to the courts and to the American people that this was not an issue that belonged to one side or the other of the political spectrum, and that it would be marvelous to have a team that was identified across the political spectrum, and so that we could talk about the fact that we were representing American values, not liberal or conservative values, that we were talking about human rights and the Constitution. And we talked about who might be a perfect counterpart to me in this case. And David's name came up, and every one of us involved in that discussion at the time said, "Oh my God, that would be perfect." David's an outstanding lawyer, probably no better in the United States. He has experience as a trial court a lawyer more than anyone in the United States, better than anybody in the United States. I do more appellate work, and we both have fine law firms. And we thought if we could put those things together and the political balance, it would be a perfect team, and of course it was a perfect team.
Many questions to ask you about the actual case, but we'll get to that later this afternoon. Let me just ask you, well, two more questions, but one serious one. The Supreme Court will hold oral arguments in Obergefell, am I pronouncing that rightly, versus Hodges about whether or not the 14th Amendment guarantees an equal right to a marriage license, essentially. Would you just tell us how to watch this case? How would you approach it if you were arguing it? And if you were arguing against it, what do you expect to see from the opponents? Maybe you've even seen the briefs. So first, just tell us how should we watch the case?
Obviously, this is a case that you want to be watching what Justice Kennedy says. He may or may not give you a clear indication of that, but he's going to be obviously a critical vote on the court. He has written the three landmark civil rights decisions in terms of gay and lesbian rights in the history of the court. All three of them. All three of them were decided 5-4. All three of them he wrote the opinion. So he is going to be, I think, a critical thing to watch. I think the arguments are going to be a replay of the arguments that you saw both in the Perry case and in the Windsor case. I don't think that there's going to be anything new. The fundamental problem for the other side is that they don't really have a principled argument. And one of the things that I think Ted and I are successful at in law is figuring out what your best arguments are for the other side, because you want to be able to meet them. Here, there really isn't an argument based on precedent. There really isn't an argument based on policy. There is an argument potentially based on religion, but that's not a proper basis for a constitutional decision. The real argument on the other side is simply a bumper sticker, a marriage between a man and a woman. That's the question. It's not the answer. And they don't really have anything behind that assertion.
I wanted to say also that in arguing this case, and there are very, very fine lawyers involved in the case, we don't know which lawyers are going to be arguing on either side, but we felt when we argued in the Supreme Court and when we argued in the Ninth Circuit and the Fourth Circuit and in a couple of district courts, one of the most important things to emphasize here is that we're talking about a segment of our society that are just like the rest of us. We might be different in terms of our sexual orientation, or we might be different in terms of our race, or our political backgrounds, or our national origin, but we are all Americans. And when we discriminate against a class of our fellow citizens, we're doing grave harm not only to them and to their children, and in every way that they live their lives, but we're doing great harm to ourselves and to our ideals and the dream of America. And that communicating that message to the justices, which I'm sure they understand, but it's important that you're not just speaking to the justices, you're speaking to the world. The audio of that oral argument will go out to the American public. They'll listen to it that evening on television, and they will watch with pictures. The networks will put up pictures of the lawyers and the justices and so forth. But you're speaking to the whole world, but particularly to America. And at the end of the day, we hope that the decision will be favorable to gay and lesbian citizens who wish to have the same rights as the rest of us, and we want the American people to accept that decision. And so we want the American people to understand this is, as the expert in our trial that David cross-examined admitted, and the other side's expert admitted at the end of the case, and we have this in the book, that we would be more true to our American ideals when we recognize the right of our gay and lesbian brothers and sisters to have the opportunity to marry. This is not just a legal case. This is an emotional case, and it's at the bedrock of America.
Beautifully put, and I think that's a great note to end on. We'll look forward to having a much longer conversation tonight. Thank you very much,
Thank you.
Ted Olson and David Boies.
Thank you, Jim.
Thank you very much.